Oh, hey, it's Josh, Santa Barbara dog walker and fiduciary governance big wheel. I'm going to share with you the 5 things that routinely slow down the settlement of mom and dad's estate. We know that there's in excess of 20 things that me and my team look for when we are reviewing an estate plan for mom and dad before they've died, and trying to identify, hey, what can be done to make the ultimate settlement smoother. I want to share with you just a couple of them. Now, the interesting thing about the elements that slow down the settlement of an estate is they're not always legal things. So they're not always things that the trust and estates attorney can help you solve, or your investment advisor, or your life insurance guy, or your CPA. These are things that the family has to solve. So, the number one thing, by far, that frustrates the intentions of the settlor, that's mom or dad when they're writing an estate plan, is they don't fund real estate. They don't fund assets into the trust. We had a case just 6 months ago. A lady needed help settling her deceased brother's estate. He had a great estate plan that had been written up. He had done it through one of the online solutions. Words were impeccable. Really well drafted. Problem was, he didn't retitle anything into the trust. So his brokerage account at JP Morgan was not in trust. His home was not in the trust. He thought everything was fine because he had a trust document. But it wasn't fine because he had failed to put anything in the trust. So failing to fund the trust is the number one frustration. Best way to figure it out is just go through the title of everything that mom and dad own that's worth more than 10 grand and ask, is it titled in the trust? If it's not titled in the trust, there's a possibility it's going to have to go through probate. Sub-item, there are some things that don't get titled in the trust and also don't go through probate. Those are things like IRAs, life insurance, annuities, anything that has a beneficiary designation. So where you can write in the beneficiary of this. Those don't go through the trust, or those don't get funded to the trust, and they don't go through probate, non-probate assets. Second thing is mom or dad didn't add the kids as co-trustees to the trust assets soon enough. So mom and dad are starting to slip in the last 5 years of their life. It would be awesome if the kids were already added to the accounts, to have access to them, to deal with the banks, to deal with the investment firm, to deal with the insurance on the home. But mom and dad resist adding the kids as co-trustees. And so then mom and dad die. And then the kids have to go through this kind of 6-week scramble to be added on all these things. So a lot of that could be dispensed with if we just added the kids as co-trustees to the trust faster. Mom and dad still have authority. Mom and dad can still remove the kids. But it would be great if that was done. Another item, mom or dad have some illiquid, difficult to value assets that nobody really knows what to do with. Classic examples are the coin collection that dad has, or the limited partnership interest in some real estate deal that dad got into sometime in the 90s. We're really not sure when. Not sure how the thing's titled. So those are the types of things. Business interests are another example. Collectible items, musical equipment, valuable antique furniture. So these are the types of things that the difficult to value assets are kind of hard to deal with, and it would be best if mom or dad gave us some heads up on these assets. Here's the guy who I bought the coins from, or here's the guy who is the general partner of the real estate deal, or here's what I think should be done with the collectible furniture. If we can get some insight from them, because they already know who the experts are, who the contacts are, we don't. We, the successor trustee, don't. So getting that can be helpful. Another item that causes a lot of frustration is no one knows mom or dad's bills. They don't know who they pay what to. They're unaware of to whom payments are owed and at what frequency. This is kind of a crossover to the one I said earlier where the kids aren't added as co-trustees to the account earlier. But not all bills require the co-trustee to be added. So getting a record of what mom and dad pay on a monthly basis. A subset of that, probably a good idea to get a credit report on mom and dad. Sometimes old folks sign up for things that they probably shouldn't sign up for. They're confused about the application that they filled out online on Facebook. And getting a credit report can be helpful because then we can know what the credit agencies say mom and dad owe to other people, what credit cards are opened. Getting that resolved or at least documented ahead of time is a big deal. Some things that can save families time. Get rid of those dang timeshares. Transferring timeshares is a pain in the neck, especially when it has to go through a probate process because nobody changed the title of the timeshare from mom and dad personally to mom and dad's trust. Now we got to probate the stupid thing if it has any material value to it. So let's get the title of those things off mom and dad's balance sheet before mom and dad die. Other things, remember in California, if the cumulative assets that are not in the trust exceed $185,000, then we got to do the full-blown probate. Under 185 grand, we can do an expedited probate with an affidavit. Not a big hassle. So I see problems with dad goes out and buys $50,000 CDs from 5 different banks because he thinks he's diversifying. And he never puts them in the name of the trust. He puts them in dad's name. Cumulatively, those are more than the estate exemption amount. Assets aren't in trust. We got to do a probate because the cash accounts, the cumulative number of cash accounts that mom and dad have exceed the maximum for an expedited probate. Other things, get rid of those safety deposit boxes. If they just have like a copy of the old will and family pictures, get rid of them. Because finding which bank the safety deposit box key goes to is a pain in the neck. Transferring the assets out, doing the inventory when there is inventory to be done with the bank manager there. It's just like a bunch of hoo-ha when all there is old birth certificates. So get rid of those bank deposit accounts or what safety deposit boxes. Those are just a few of the things. The Anados team has stubbed our toe on every single one of these and many, many more. We've got a running list of probably 25 of the most common things that slow down a trust and estate settlement and the thing that the family can do ahead of time to fix it. I'll share that with you guys somehow. Like go to our website and I'll figure out a way to get that to you or just email me. But having a process of identifying ahead of time what is going to slow down the settlement and proactively doing something about removing those impediments is an important thing. It's also a service that we provide. We call it the estate review. Sometimes amendments need to be done to mom and dad's trust documents. Sometimes assignments of assets from their own name into the trust need to be made, like the timeshare. Sometimes deeds need to be updated. Sometimes accounts need to be closed and retitled. Sometimes instructions need to be made about what to do with the 64's VW that the kids are going to fight about, or dad's watch, or the coin collection. So going through a review process is something we love to help with. We charge a fixed fee of $3,000 and collect a bunch of docs, interview mom and dad, get it done. So give us a call if you think we can help. Our website is trustee-help.com. Ciao.